Good afternoon, everyone, and welcome to the fourth in this webinar series at Switalskis Solicitors. Thank you for attending, and I hope you'll very much enjoy this session. Thank you for the time given by all our speakers during this series and the gift of their expertise and their experience. All our webinars will be on the Switalskis website, so you can go back into them at any time. Can I ask that you ask any questions through the Q&A facility rather than the chat? It's just so much easier for us to manage. Without further ado, today we have Neil Allen joining us. Neil is a barrister at 39 Essex Street Chambers and teaches undergraduates and postgraduates at the University of Manchester. He's known to many of you. He specialises in mental health, incapacity and human rights law. And today he talks to us about the progress, or otherwise, of the liberty protection safeguards. Over to you, Neil.
Thanks ever so much, Alison. And yeah, progress seems to be in sight. I want to sort of go through the backbone of the liberty protection safeguards and flag up some of the differences between the law as it stands now and how it's looking to stand next year. And then outline a few concerns, but also benefits of the new scheme. So if we have a look and start where we all are familiar, Article 5, which obviously secures the right to liberty and security of every person, regardless of age. And it's worth flagging up straight away that the liberty protection safeguards will be available from the age of 16, whereas of course DOLS is only available for adults. So we'll still be using the High Court's inherent jurisdiction in relation to under 16s. No one should be deprived of liberty save in certain scenarios, and of course any deprivation must be in accordance with a procedure prescribed by law. And as we know, the Cheshire West case greatly expanded the concept of what it means to be deprived of liberty. It wasn't a DOLS case, of course, but the fallout of that case meant that DOLS was no longer fit for the purpose that it was designed for. And instead we have the liberty protection safeguards, which is meant to sound nice and warm and cuddly. So rather than referring to people as detained residents, they will be called cared for people. Rather than referring to a place of detention, which is how DOLS is phrased, we'll be looking at the particular place. So it's a scheme that's meant to be easier to explain to family members, but of course, ultimately, we are focusing on deprivations of liberty. And obviously, there's the right to challenge any deprivation. And recent case law, the Hillingdon case, suggests that in Section 21A proceedings, which of course need to be decided speedily by the court, if there are issues relating to the DOLS assessments, forms 3 or 4 in particular, then we should go back to, or get permission to go back to the assessor, and if necessary, call them to give evidence. That's a much more speedy approach to take than going down, for example, a Section 49 route. Okay, so legal procedures for detaining those of unsound mind. Obviously, the Mental Health Act is a legal procedure for psychiatric detention in hospital. Other than in very limited exceptional circumstances, so Section 135 and 6 or Section 17, leave of absence, we cannot rely on the Mental Health Act as a legal procedure to deprive someone of their liberty outside a hospital. And the case said that the conditions of a conditional discharge can restrict but not deprive. And similarly, the PJ case said that conditions of a CTO can restrict but not deprive. So the Mental Health Act is for hospital detention for psychiatric purposes. And of course, within the Mental Capacity Act, we have principally two legal procedures, the Court of Protection and doles. And the highlighted bits essentially are those that are being replaced by LPS. So for uncontested deprivations of liberty in the community, at the moment we're going to court with the COP 11 form and the evidence in support, whereas in future we will be using LPS, and LPS also replaces doles. And then as a gap fill, of course, in very limited circumstances, we have the High Court's inherent jurisdiction. So this is the sort of planned milestone that the government is working to. So if we start on the left, this was already slightly late, but last month we had a revised impact assessment produced. And that was described as incomplete and non-final, which is incredibly helpful. It was based on the 2018-2019 doles figures, and also it doesn't take into account the government's decision towards the end of last year to ditch the alternative care home manager process under LPS, which they decided to bin at this stage. So the impact assessment is not entirely reliable. I'm going to be referring to it this afternoon, but take the figures with a hefty pinch of salt, perhaps. But it's still useful because it gives you an idea of what the government is expecting to happen with LPS when it comes into force. So we'll probably have a new impact assessment closer to the time. This spring, although it's probably going to be late spring, I would guess, we're going to have a draft code of practice and regulations out for consultation. So if you've got a view about LPS, the summer, it is your opportunity to inform the quality of the code of practice and regulations, because once that's finished, they will be put before Parliament in the autumn. The code will then be published at winter, and the regulations for the approved mental capacity professionals will come into force early next year. And that's all geared towards a start date in April 2022, which is not long, to be honest, given how much preparation is going to be involved. And the government anticipates that there will be about 258,000 requests or applications per year for liberty protection safeguards. So that's probably an underestimate. It's probably going to be something closer to 300,000 that we will see. So this is the Act of Parliament that's brought in LPS. As you can see, it's pretty short and sweet. There's not a lot to it. And you might think that's far better than doles, which went on forever and was quite a challenge to get your head round. Even judges struggled to do that. So this is very different right from the outset. It is short, it is sweet, and a lot of the important detail, I think to some extent regrettably, but anyway, a lot of the important detail is going to be in the code of practice. All right, there's a really heavy reliance, it seems, on the code of practice to try and address what will be fairly significant legal issues. Now, because we're talking about deprivation of liberty, that's obviously the phrase that's used in the Act itself. And obviously this is amending the Mental Capacity Act. But in practice, we will call it the Liberty Protection Safeguards. Whatever you do, don't refer to it as LIPS, because we're not supposed to. Even though I think that's the title of today's talk. Okay, so what is this procedure then that's being prescribed? I'm going to go through this in quite a bit of depth to try to help us get a flavour for how this is likely to work in practice. So the first thing to note is that someone, X, no idea who that's going to be, but someone, we hope, will identify as part of the care planning arrangements that the plan is to deprive the person of liberty. I anticipate this is going to work quite similarly to how it is at the moment, in that, if you're, let's say, a social worker and you're assessing someone's needs and the care arrangements are likely to deprive liberty, we would expect you as the social worker to flag this up as a case requiring safeguards. Similarly, if you're already in a care home under DOLS, we expect the care home manager to flag this up, request the safeguards, and if they don't, following our request within 24 hours, we can go above their heads. So it's not clear, there's no sort of clear legal role under LPS in terms of who should flag this up, but on the face of it, it would seem anyone interested in the person's welfare could do so. Like DOLS, LPS is meant to be preventative. In other words, all the work that goes into LPS is meant to be done before the deprivation of liberty begins. And as I say, that's exactly how DOLS is designed, but how often have we ever really seen a case where DOLS is triggered up to 28 days before the deprivation, the assessments are done before the deprivation, and the authorization is given before the deprivation? It hardly ever happens. And so I fear, or suspect at least, that the same will be true under LPS. Even though it's designed to be triggered in advance, and the safeguards are needed in advance, it will feel a little bit like deja vu, I anticipate, but perhaps not as much of an afterthought as DOLS is in some cases. So we flag up that this is likely to be a deprivation, and we contact what's known as the responsible body. And I'll say a little bit more about responsible bodies in a while. Obviously, at the moment, the Court of Protection is responsible for DOLS safeguards in the community. And in England, it's the local authority for hospitals and care homes. In Wales, it's the local health board for hospitals and local authorities for care homes. So there are 5 main things that the responsible body will be doing. They will be taking steps to determine, first of all, whether the conditions of LPS are satisfied. Okay, there are 3 primary conditions that must be, or criteria, if you like, that must be fulfilled for the person to be subject to DOLS. Secondly, they must take steps to carry out the relevant consultation. Thirdly, appoint what's known as an appropriate person, an AP or an IMCA. Fourthly, to carry out a pre-authorization review, so scrutinize the assessments that have been received and determine whether the authorization ought to be given. And that pre-authorization review must be done by an approved mental capacity professional. That's the future BIA, if you like. The AMCP or AMCAP, whatever term we're going to use. The AMCP must carry out that review if it's an independent hospital deprivation case or what's going on is against the person's wishes. And I'll say a bit more about that later on. Other than in those 2 scenarios, it doesn't have to be an AMCP, it could be someone else that does the review. And then 5th, the responsible body, if satisfied that all the requirements are met, don't have to, but may then grant the authorization. So the first bit of fun with LPS is going to be which body is responsible. Well, we have 3. If the deprivation of liberty is occurring or going to occur in an NHS hospital, then it's the manager. So brand new role here, it's the hospital manager of that NHS hospital that will be responsible for these steps. Secondly, if someone is not in hospital but receiving NHS continuing healthcare, if their arrangements are mainly provided under NHS continuing healthcare, then it's the CCG that will be the responsible body. Again, brand new role for them. And then in all other cases, so the community cases, care home cases, if someone is not on CHC funding, as well as private hospitals, independent hospitals. It's the local authority that will act as the responsible body. So they've very much taken over, if you like, the work that the Court of Protection is currently doing. All right, so let's have a look at these 5 key steps that responsible bodies must take. And let's start with the conditions. There are 3, and it is not entirely clear from the legislation as to who will be undertaking these assessments. One thing we do know is that what's known as the medical assessment must be done by a medic. Okay, there's no ifs or buts about that. In human rights law, the medical assessment, which looks at does the person have a mental disorder, that has to be done by a medic. But we wait to see who will be conducting the other assessments. Looking at the impact assessment, the government believes that it's doctors, social workers, AMCPs and advocates that will take on the bulk of LPS. Okay, doctors, social workers, AMCPs and advocates, they are the 4 groups of professionals expected to take on the largest role of the new scheme. So many social workers, I anticipate, will be asked to assess capacity. And as you can see, the issue here is whether the person, the cared for person, lacks capacity to consent to the arrangements which deprive them of liberty. Okay, do they lack capacity to consent to the arrangements? Now, we can use, as we can under DOLS, we can use equivalent assessments, in other words, prior capacity evidence, if it's reasonable to rely upon that previous assessment. Okay, so equivalents are permitted. Whether it's reasonable to rely on them will depend on those sorts of factors. So how long ago it was done, why it was done, and whether there's been any change in the person's condition that is likely to affect the outcome. A grand total of £162 has been costed for new mental capacity assessments, but it's anticipated that a new capacity assessment will only be needed in 40% of cases. Okay, so 40% of the 258,000 per year. So it's anticipated that the remaining 60% will very much be based on equivalent assessments. So I anticipate that the incapacity evidence is going to be largely provided by social workers and doctors in the main, but probably social workers more often than not. Secondly, the medical assessment. So this is looking at whether the person has a mental disorder, exactly as we do under DOLS. Again, we can use equivalent assessments so that these are not being reassessed every time if it's reasonable to rely upon a previous assessment. And a grand total of £115 has been costed for this assessment. And it's thought that only about 20% of the 258,000 a year will require a medical assessment. Okay, so again, it's anticipated that in the vast bulk of LPS cases, we will already have evidence of mental disorder. And the impact assessment believes that this sort of 20% will mainly relate to 16 and 17-year-olds, where perhaps there isn't already an established diagnosis of mental disorder. Okay, so not a huge demand, it seems, for medical assessments because it's expected that that evidence will already be available. And then the third condition, the third assessment, is necessity and proportionality. So much like under Section 6 of the Mental Capacity Act, we're looking at whether the arrangements are necessary to prevent harm to the cared for person and whether they're proportionate to the likelihood and seriousness of harm occurring. So it's the necessity and proportionality issue. However, and I think perhaps quite importantly, we have to have regard, amongst other things, we have to have regard to the cared for person's wishes and feelings in relation to the arrangements. Okay, so first thing to notice is that there is no express best interest assessment. That's gone. The reason it's not there is because, of course, you shouldn't be triggering the scheme unless incapacity and best interest have already been considered. Okay, so best interest has disappeared. We are left with necessity and proportionality, but the fact that we need to have regard to wishes and feelings may, to some extent, enable some of the good bits about best interests to kind of factor through into the necessity and proportionality test. Okay. The second thing to notice about that is that we cannot use equivalent assessments at all. So for every authorization, we will need a fresh necessity and proportionality assessment. It's being costed at £152. Again, you know, how much weight to put on this impact assessment remains to be seen. But anyway, it's costed £152. And interestingly, the impact assessment does say that they're hoping that necessity and proportionality can be streamlined with care planning, where that takes place under the Care Act or for NHS continuing healthcare purposes. Okay, so they're expecting that about 40% of necessity and proportionality assessments might already have been considered as part of that parallel sort of care planning process, leaving 60%, that's about 155,000 per year, requiring a standalone necessity and proportionality assessment. All right, so those are the three assessments. Those are some of the figures that illustrate the government's thinking on this. In terms of training, full training for LPS is going to be required for all adult social workers, and it's estimated about 20% of doctors, children's social workers, and other social workers will require full training, and then everyone else will require awareness training. And obviously AMCPs will require training specifically for their role. All right, so those are the three conditions. Then we move on to consultation. So the responsible body, NHS manager, CCG, local authority, must consult, and we have a list of consultees, which I'll just quickly read out. So that's the cared for person. It's anyone named by them who they want to be spoken with, anyone engaged in caring for them, any donee of an LPA or EPA, any deputy and any appropriate person, and any IMCA. So we have a list of statutory consultees that must be consulted with unless that is not practicable or appropriate. And crucially, the main purpose of that consultation is to work out, to try and ascertain what the cared for person's wishes and feelings are in relation to the arrangements. Okay, so it's not necessarily to get the views of those consultees on things like best interests or necessity and proportionality or capacity. The main purpose of it is to ascertain the person's wishes and feelings, which then obviously factor into necessity and proportionality. So that's the second thing responsible bodies must do, consult. Thirdly, advocacy support, to describe it loosely. So essentially, under LPS, there will have to be either an appropriate person to represent and support the individual. Appropriate person is very much like your unpaid RPR under DOLS. Okay, so an appropriate person or an IMCA. Okay, so interestingly, the impact assessment suggests that 5% of LPS cases, which is almost 13,000 people, will not have either one of those. Okay, so the impact assessment estimates that 5% of people will not have this what you might think is a fundamental safeguard. Why is that? Well, I can only imagine that they might think that the cared for person with capacity decides that they don't want anyone, or perhaps the responsible body has taken all reasonable steps to appoint an IMCA, but ultimately they have failed to do so. Okay, but I think that is quite a concern, bearing in mind that if you go back to Bournemouth, one of the big criticisms of the European Court was the lack of representation for those deprived of liberty. So personally, I think it would be quite dangerous. I think responsible bodies would be on very thin ice if they fail to appoint an appropriate person or an IMCA. What is worrying, and I'll come back to this later, is that it's not an absolute obligation to get an IMCA. The responsible body need only take all reasonable steps. What does that mean? I'm sure the code will tell us. What is good, though, importantly, is that this support, this advocacy support from either your family member or your friend or an IMCA, for example, that's there while the arrangements are being authorised or are being proposed. In other words, that interim period before the authorisation requires that sort of support. And similar to DOLS, we can also have an IMCA to support an appropriate person. Okay, so those are the sort of advocacy provisions. It's estimated that 75% of those under LPS will have an appropriate person, and 25% will have an IMCA. And it's anticipated that just over 10,600 new IMCAs will need to be trained up. Okay, they'll have to be quite a significant ramping up of IMCA provision for this to work. Okay, so we've identified this as a deprivation potentially. The responsible body has organised the assessments to be done. We've made sure that there's an appropriate person or an IMCA in place whilst this is being done. And then once those assessments have been received, there must then be a pre-authorization review. Now, this is done by someone independent. And the easiest way to think about this is that if you think of DOLS, within the local authority, they receive Form 3, Form 4, that is then scrutinized, and then Form 5, the authorization is granted. So that's the role we're talking about. At the moment, it tends to be a group of people fairly senior within local authorities that scrutinize the assessments with vigor, and if satisfied that the criteria are met, they then sign off the authorization. So that's what we're talking about. And by independent review, independent is quite loosely interpreted. So we're not talking about someone who's independent of the responsible body, someone outside the local authority, for example. We're talking about someone who is operationally independent. So someone who is not involved in this person's day-to-day care or providing treatment. Now, I think local authorities in England are pretty well geared up for this because they're used to undertaking this role. But this could be more of a challenge for NHS hospitals who currently don't do this role, and also CCGs in continuing healthcare cases. All right, so someone who is operationally independent, or, and this is really one of the key safeguards, or the review must be done by an approved mental capacity professional in one of three circumstances. Okay. Now, the reason this is important is because, as we'll see in a second, here we're talking about someone actually coming out to see what's going on. We're talking about boots on the ground rather than a sort of desktop exercise, which independent reviewing would otherwise be. Okay, so the triggers, if you like, for an AMCP are either this is happening in an independent hospital. So any deprivation in an independent hospital must have an AMCP involved. Or secondly, it's reasonable to believe that the person doesn't wish to reside in this place or doesn't wish to receive care or treatment at this place. Okay, so what I loosely call sort of against the wishes cases. Very important. So if someone is accommodated anywhere other than, let's say, an independent hospital, a care home, supported living, community, own home, because of course this could apply to people in their own home, if it's reasonable to believe that they don't wish to reside there or receive care or treatment there must be an AMCP. And then the third scenario is if a case is referred to an AMCP by the responsible body and the AMCP accepts that referral. And that might be, for example, where the appropriate person or the IMCA is seeking some kind of review prior to going to court. Okay, so the independent reviewer or the AMCP, they have to consider whether it's reasonable to conclude that the conditions are met. For independent reviewers, as I say, that's a desktop exercise, so query how much of a safeguard that is. But if an AMCP is called out, they must meet the person, if that's practicable and appropriate. They must consult with the people on the list. And then I think fundamentally, they can take any other action if it appears to them to be appropriate and practicable to do so. Okay, so they can take any appropriate and practicable action. And I'll say a bit more about this later, but how that is interpreted in the code of practice is going to be absolutely fundamental to how good or bad LPS proves to be. So that's the pre-authorization review. And then if everything is tickety-boo, then the responsible body can authorize on that basis. We can do this up to 28 days before the deprivation begins. And there will be an authorization record, a bit like your Form 5 for DOLS, an authorization record with a start and end date, a program for review. That's something new, all right? So there'll be a program. You can include reviews during the length of the authorization, and that can be delegated by the responsible body to care homes, as well as details about the safeguards. And all that information must be provided to the person and others in an accessible format within 72 hours. And that's one of the good things I think about this, is that it's beefed up the importance of ensuring that people know what their rights are, because what's the point in having rights if you don't know about them? Okay, so that's the authorization record. That authorization then gives people a defense to liability. Like DOLS, it doesn't actually authorize care and treatment, but what it does is give a defense to liability for acts done in pursuance of the authorization, and that can be varied if it's reasonable. And then for the IMCAs and lawyers amongst us, how do you challenge an authorization? Well, anyone with an interest in the arrangements, well, that seems to be fairly broadly defined. Anyone with an interest in these confining arrangements can make a reasonable request for a review. And as I say, that's likely to trigger an AMCP. But always, that's not going to be a hurdle. There will always be a right of access, a direct right of access to the Court of Protection through Section 21ZA challenges. And importantly, non-means tested legal aid they've promised will be available. Obviously, we already have that for DOLS, but we don't have that for 16 and 17-year-olds or community cases. So extending the provision of non-means tested free legal aid. Okay, so that's how it's looking. That's the procedure prescribed by law. We need to start preparing if we haven't already, because, you know, NHS managers, CCGs will be taking over responsibility for Article 5 safeguards. So they need to think through how they're going to operate that and what the implications are. It's really important to develop staff confidence in the very basics of the Mental Capacity Act. So bear in mind that the expectation is that these assessments will not be done by someone independent. The expectation is that these assessments, or the bulk of them, I think about 75% of them at least, will be done by those who are already involved in the person's care planning arrangements. So it's my own social worker, it's my GP. They will be responsible for the assessments. Although good luck in persuading GPs to do it. So making sure that the very core of the Act is properly embedded. If that's done, LPS will follow through fairly easily. Capacity, best interests. Do we know how to determine necessity and proportionality? Can we spot the difference between a restriction and a deprivation? What I've suggested here is that the COP-DOL 11 form, nightmarish as it is, being 31 pages, but a sort of that form, the good thing about that form is that it kind of flags up some of the key issues that are likely to carry forward into LPS. So if you have a look at that form, that might provide us with a bit of a template, although we'd want to shorten it, but a bit of a template as to the sort of evidence and questions that we will need to answer when LPS comes into force. There's a lot of scoping required. You know, what are the numbers going to be? We've got some fairly dodgy numbers from the impact assessment. As I say, it's likely to be a lot more, but we need to look at how many people are deprived in independent hospitals, care homes, the community, children's homes, residential special schools, people in their own home. One of the big issues is to what extent will LPS stretch into family homes, because we've got a lot of people in that scenario, and then that has a bearing on how many AMCPs we need, as well as how many IMCAs we need and how many independent reviewers we need. So there's a lot of scoping required, and of course the government needs to provide an updated impact assessment to make sure that it's accurate as it can be at least, and importantly to make sure that the funding is available for this to work. Okay, so my kind of summary of LPS is I think more people will get safeguards, but compared to DOLs, those safeguards have been watered down. So it swings and roundabouts. More people will get safeguards, which is great, because we have hundreds of thousands of people that don't currently have safeguards, but the actual quality of the safeguards compared to DOLs is less. Now, I'm not going to go through this slide because I want to leave plenty of time for questions, but have a look at this afterwards. What I've tried to do is kind of do a spot the difference between what the law requires in terms of restricting liberty, the current safeguards under DOLs and the Court of Protection, and then compare all that with LPS. There's just a couple of things I wanted to stress. Firstly, the necessity and proportionality assessment under LPS, that's one of the key ones alongside capacity, of course, but we should already know how to do that. Because even if you're restricting someone's liberty, you've got to make sure that those restrictions are necessary and they're proportionate to the risks. So again, if that's well embedded now, then it will be easier to implement LPS going forward. An example of weakened safeguards is that under DOLs, in law, obviously not in practice because we have a lot of unassessed people, but in law, under DOLs, everyone gets or is entitled to an independent best interest assessor. Whereas that's not the case for LPS. It's only independent hospitals, and if this is against the person's wishes, that they'll get an AMCP. All right, so that's one of the, it's an example of how LPS is watered down. The other main concern I have, and I'll come back to this, is about the interim provisions, which are far more generous, but I'll come back to that in a second. So let's have a look then at a kind of an appraisal of LPS. First of all, concerns. There is a heavy reliance on the code of practice. which is why it's so important to get that right. There are some fairly major legal issues that are not addressed by the legislation, and I've just given some examples here. So there is no statutory deadline for completing the LPS assessments, and there is a very generous interim legal cover pending authorization. So let me just explain that in a bit more depth. So obviously under DOLS, we have a 7-day urgent authorization, extendable by another 7 days if there are exceptional reasons. Okay, that interim urgent period has deadlines on it. In practice, often they are breached, but it's the legal provision that counts for these purposes. There are statutory deadlines for dealing with urgent cases. Whereas under LPS, it's very different. Once the assessments have been done, our back is covered so far as Article 5 is concerned. Whilst we're waiting for LPS to be processed, for those assessments to be scrutinized and for the authorization to be given, in the interim, it's lawful to deprive, and there is no statutory deadline. And again, bear in mind, going back to Bournemouth basics, another criticism that was made was that at common law, we had no limits in terms of time. And similarly, LPS, when it comes to that interim stage, has no limits in terms of time. The other concern, potentially, is that the contact requirement for the representative has gone. So under DOLS, RPRs, paid or unpaid, have a kind of 2-dimensional job description. One is to represent and support the person in relation to the authorization, and the second is to maintain contact, which obviously has been on a more virtual kind of level in the last 12 months. But nevertheless, there's a contact requirement. Under LPS, that's gone. All it requires is the appropriate person or IMCA to represent and support the cared for person. Now, does it matter that there's no requirement to maintain contact? Personally, I think it does, for no other reason other than, funding normally follows legal obligations. And so query whether there's going to be enough funding, particularly in relation to the IMCA role, if there's no legal requirement to maintain contact. Now, again, the code of practice could address this, because the code might say, at least insofar as appropriate persons are concerned, you're not an appropriate person unless you can maintain contact. So we could address that legal concern through the code, but of course the code is not sort of law in the same way as the legislation is. The other concern I've got in relation to the impact assessment is, I say, they estimate that 5% of those subject to LPS will not have either an appropriate person or an IMCA. How on earth can that be right? Everyone, in my view, should have one or other. Another concern, those of you who are lawyers, this could well be the first test case. There could be a bit of an argument as to who is responsible, which body is responsible, because when you look at things like NHS continuing healthcare, it talks about whether the arrangements are mainly provided through NHS continuing healthcare, or in terms of hospitals, whether the arrangements are mainly provided in hospitals. So what does mainly mean? How long do you need to be in hospital for before the arrangements are mainly done in hospital? What will happen to best interests? I say it's gone, but will necessity and proportionality limit the damage? The cornerstone, as it was said in the Neary case, the cornerstone of DOLS, the independent best interest assessor, has gone, except for independent hospital and against the wishes cases. Who is going to flag up that this is against the person's wishes? That is a real concern. And in terms of domestic settings, it's going to be interesting to see how families react when it comes to the stage of looking at LPS for deprivations occurring in the family home. Again, I imagine we're going to have a sort of Cheshire West, the sequel, which looks at the scope of Article 5 when it comes to family homes because of the impact that has on Article 8 rights. But it's not all doom and gloom. There are benefits. The first benefit is that we don't have the Cop Dole 11. And that's a massive attraction. For community cases, we won't have to be going to court and following what is quite a tricky process. Instead, it will be done through mostly the local authority. Also, CCGs and hospitals, as well as local authorities, of course, will have to take ownership of Article 5 safeguards. But bear in mind, when doles first started, we had PCTs that had taken ownership of doles, and look what happened there. There's a risk of deja vu. LPS really does focus on us sorting this out before the dole begins. But again, so does the current scheme. Will it better embed the Mental Capacity Act in practice? We hope so, but of course, that's going to very much depend on training. And ultimately, I think one of the good things about this is that more people will have safeguards, albeit less in quality. A few things there to help you keep up to date, and I'll pause there for questions. Over to you, Alison.
There's a worrying silence there, Neil. I'm sorry about that. That was me and my IT, lack of IT skills, rather. So thank you for that, Neil. Let's go over to the questions. So the first one is, apologies if this is covered in the talk already, but what will happen to patients we have on doles when LPS comes into force? Will they automatically transfer, or will a new application have to be made for every patient? Thank you.
Yeah, thanks, Tracy. That's a good question. And basically the answer is, for the first year, so from April 22 to 23, for that first year, both schemes will run in parallel as people are jumping from one boat to the other. Okay, so if you are currently under doles, let's say to September 2022, then you will remain under doles, but then for the next authorization, it will be under LPS. And the same applies to court orders if they expire beyond April 22. So they will run in parallel as we jump over from the current law to LPS. They will not be automatically renewed.
Okay, I've just gone down a little bit too far. I had a question from Maria. Just let me get back up to it. So Maria says, what are those 3 conditions which are determine an LPS is happening?
Incapacity, mental disorder, and necessity and proportionality. So the government sells LPS as a much more simple, streamlined scheme. Of course, we still need to consider the person's age. We still need to consider eligibility. And interestingly, it's not clear at all who is going to be looking at eligibility. In other words, how does LPS relate to the Mental Health Act? But we still need to consider eligibility. And of course, LPAs for health and welfare, as well as deputies, will have a sort of veto, if you like. But primarily, those are the 3 assessments: incapacity, mental disorder, and necessity and proportionality.
Thank you. And Anne asks that CCGs are being decommissioned in 2022-23 as part of the NHS long-term plan, with their roles being taken over by integrated health and care partnerships /systems. Will the responsible body role of the CCG also go to these ICSs?
No idea, Anne. We will wait to see. I'm not sure about the exact time frame, because I think we have a white paper in this regard, don't we? And I know Mr. Hancock is quite keen to get this through, but obviously it's going to take parliamentary time. So query whether it's going to happen in 22 to 23, but if and when it does happen, then of course LPS will need to be amended to ensure that the current CCG role is appropriately passed over to whoever's going to replace CCGs.
Thank you. Matthew asked, does medic include non-medical approved clinician?
No, in a word, Matthew. It needs to be someone with objective medical expertise. So that's going to be either a GP or a psychiatrist.
Okay.
There might be some debate about psychologists, but I anticipate that when the regulations come out and the code of practice, it will probably say it must be a GP or a psychiatrist. And that's mainly because of human rights law.
Thank you. Do continuing healthcare nurses require the full training, or will they be only receiving the awareness training? That's a good question, actually.
Which nurses? Sorry, Alison.
Continuing healthcare nurses. Or is it? Yeah. Or will they just
no idea.
Second tier of awareness training?
Yeah, we don't know. Like as I said, the impact assessment, pinch of salt really, because nurses are not referred to at all expressly. But when you think in particular about CHC cases and hospital cases, I don't imagine it's just going to be social workers and doctors doing these assessments. I'm sure ultimately they will be looking for other professionals to share the LPS love. Bearing in mind that one of the whole aims of the game is to better embed this for all health and social care professionals to take ownership of the Mental Capacity Act. So I don't know whether it's going to be mere 2 hours of awareness training or perhaps a full day or two of LPS training. That's all the particular training requirements are going to be set out in far more detail, probably at the end of this year.
Thank you. And Claire asks, would advocacy capacity be a mitigating factor in delays for appointment of an AP?
I don't see. Well, Claire, if you mean if we think that this person has capacity to make a decision around having an appropriate person and they don't want an appropriate person, and therefore we need a bit of time to work this all out, then maybe that could provide reasonable grounds for delay. But if capacity is sort of not in dispute, then we need to press ahead. Like as I say, it's really important, I think, for cared for people, which is ironic anyway, because this is meant to happen in advance before they are cared for. Anyway, I think it's really important for cared for people to have access to an appropriate person or an IMCA. And even if I don't want, let's say, my family member or my IMCA, nevertheless, I still think I should have that available. And then it's for the IMCA usually to decide how to approach me. And maybe this will be a very light touch form of advocacy. As I say, I think that's probably a court case waiting to happen. If a responsible body decides not to appoint one of these representatives, potentially that is a court case waiting to happen.
Thank you. Will legal aid cover be available for a cared for person in their own home and supported living? Yeah.
Well, that's what they promised before the pandemic, I should say. That's what was promised. So yeah, wherever LPS is being used, whether that's a care home, a hospital, children's home, residential special school, your own home, supported living, what they've said previously, and I can't see any reason to backtrack on this really, is that free legal aid will be available. The only thing we don't know is whether it will be available during that interim period, or will it be available only if an authorization is granted. That's one thing we don't know. And it's quite an important detail because you need to know that. Yeah.
Yeah. Jill asks, who will the responsible body be in joint package of care cases, such as the the local authority and the CHC or CCGR?
Again,
well.
Good question, Jill. There's a lot of kind of debate about this in some quarters. My sort of interpretation of the legislation is that the short answer there would be local authority, because when it talks about NHS continuing healthcare, what we're talking about is someone where we've done a decision support tool, they've got a primary health need and therefore qualify for fully funded NHS continuing healthcare. That's what we mean, I think, by NHS continuing healthcare, fully funded. So there isn't, unless there are some kind of residual social care needs that are completely unassociated with my health need, these packages are not jointly funded. Okay, we're talking about usually 100% NHS continuing healthcare cases. Notice also that there's a difference between NHS continuing healthcare and children's continuing care. Okay, so CCGs won't be dealing with children's continuing care, that'll be local authorities. And similarly, if there is a jointly funded package of care that's not CHC, that would be jointly funded 50-50 health and social, it will be the local authority that will be responsible for the safeguards.
Thank you. And Peter asks, I'll try and put the question together. This suggests that many people are already unlawfully deprived of their liberty. Do you think that LPS will improve matters if a person suddenly then objects? What then?
Yeah, thanks, Peter. That in law, there are no changes to the interface with the Mental Health Act. I think that's the first key thing. No legal changes at all. And obviously at the moment, it is not common for someone to be under doles when they're detained on a mental health ward. Usually it's the Mental Health Act. But what I think it will change, and this is a slight concern of mine really, is that I can see LPS being used more on mental health wards in future. I can see, for example, people going from a Section 2 into LPS whilst on that mental health ward. And that's because the assessors have changed. So we won't have, an independent doctor coming out from the local authority to say, sorry, mate, this is an objective mental health case, you need to use the Mental Health Act. Instead, the assessments will be done by those on the ward. For example, the responsible clinician. And so there is an issue there, because will those objections be flagged up? Or will they kind of be muffled within the LPS assessments? So there's no change in law, but what you might see is a change in practice and a greater use of LPS on mental health wards. And I think there is a debate to be had as to whether that's a good or bad thing. But that's certainly something I'm anticipating will happen. And of course, it then has a bearing on 117 aftercare and everything else.
Thank you. Claire asks, how do you see the Mental Health Act reforms interacting with LPS, taking into account proposal that learning disabilities and autism will be removed from the scope of the Mental Health Act? Will we see more LPS detentions in psychiatric settings? Will they meet the mental disorder element of the LPS authorisation?
Okay, thanks, Claire. So let me just break that down. Obviously, the mental health reforms are very much in their kind of infancy at the moment. It could take years before anything is actually legislated in that regard. But under the proposals, we can still use Section 2, but not Section 3 for learning disability or autism, unless there's a probable mental health cause to their behaviour. So the short answer to your question is, you might not see much of a change in terms of Section 2s, but if the Mental Health Act is reformed along the lines of what the white paper suggests, there is a real risk, and it is a risk, that people with autism or learning disability will still be detained in hospital, but under LPS. LPS will be available, and yes, they will meet the mental disorder requirement, because we don't need any seriously irresponsible conduct or abnormally aggressive behavior. It's simply, do they have autism or learning disability? So on the one hand, the white paper is trying to ensure that those with autism and LD are not detained in hospital inappropriately. But what you might end up seeing is LPS being used to do exactly that, with arguably less safeguards than you would get under the Mental Health Act. So that is a real concern.
Yeah. Neil Sophie asks, hi, is there no route to challenge in the Court of Protection?
Yep, there is, Sophie. Exactly the same as Dole's. So the individual themselves, their appropriate person or IMCA will have the right to bring a Section 21ZA challenge straight to the court. I think in practice, what we might see is, if this is against my wishes, or maybe I'm settled at the moment, but then my wishes change, and actually now I don't want to live here, thanks very much, or maybe I've started to refuse personal care or medication or whatever. Under Dole's, we do have a review process. We do have a Part 8 review, but it doesn't tend to be used much. Instead, we tend to jump straight to the Court of Protection. And I think that might change in future. I can see us in future going to the AMCP first. We won't have to go to the AMCP. We can always jump straight to court because you have the right to have a judge look at what's going on. But what you might see is some cases being sort of filtered out if the AMCP can address the issues. Whether they can address the issues depends on what does, appropriate and practicable action mean. How weighty, how beefy is the AMCP role actually going to be? The more powerful the AMCP role is, the less we may end up taking to court. And just while I'm on that, it's estimated, this is for the lawyers really, 0.5% of authorizations will go to court. That's the estimate. Which is about 1,290 per year.
It's not very
in case
many.
You're planning for your pension. It's not, is it?
No. Kate, asks, says no time limits, question mark. Does this mean that if the care home forgets, there is no legal right to hurry them up? Like now we can say it's unlawful.
So Kate, we'll still be able to kind of, if you like, go above their heads to the responsible body. I don't see anything in the Act that would prevent us, going above their heads in the same way as we can do at the moment. What my concern relates more to is how long it might take for the LPS assessments to be scrutinised. So translating that to Dole's, what I'm talking about is that time gap between the assessments being done and the authorization being granted. In some local authorities, that can take weeks, even occasionally months. So that's really where I'm concerned in terms of time limits.
Sheila asks, how are they planning to train 10,000 IMCAs? It's a fair question.
No idea, Sheila. I'm sure we'll find them somewhere, and there'll be some great training providers out there, no doubt. But yeah, it's again, this is a good thing about LPS. The impact assessment recognises that we are going to need a lot more IMCAs, and so hopefully there'll be a real investment in advocacy support.
Catherine asks, do you think the LPS will start in, sorry, I've just missed my place, in April 2022. Do you think that's realistic?
Well, depends which variant of COVID we're on by that stage, Catherine. If we're on the sort of 56th version or variant of COVID with the, I don't know, Hawaiian variant or something, then things might be delayed. I don't know, is the short answer. The official, or the last sort of official pronouncement was April 2022. Obviously, it's already been pushed back. This should already have come into force in October of last year. It's already been pushed back 18 months. I really hope it is April of next year.
What if a patient is objecting and deprivation is in a hospital?
Okay, so that will what we'll have to do in that situation is, first of all, work out why are they in hospital. Is it mainly to address their mental health or physical health? If it's their mental health and they're objecting, then we look at the Mental Health Act anyway. If they're primarily in hospital to address their physical health, and it's an NHS hospital, and this is against their wishes, then they need an AMCP. So they will get the extra safeguard of the AMCP. If it's a private hospital, they'll get an AMCP anyway, even if they're entirely happy to be there. Private hospitals, automatic AMCP. So that's how it's going to work. And this relates to Peter's question as well about the interface. So like now, we'll have to think about what's the main purpose of that hospital detention. Is it for physical or mental health? If it's mental health, if they're objecting, Mental Health Act. If it's physical health and they're objecting, then they must have an AMCP who can take any appropriate action. And of course, if LPS is authorised, you then get all the safeguards and you can challenge your hospital detention in the Court of Protection like you can under DOLS.
Thank you. Yvonne asks, you mentioned doctors' responsibility, but in practice, it is the mainly nursing staff who request DOLS in hospital. Do you think they will have a role regarding collecting the information for the pre-authorisation review?
Yeah, Yvonne, it is difficult to say. Put it this way, I was quite surprised that there was no reference to nurses in the impact assessment. You know, that the focus is much more on social workers and doctors. To be fair, the impact assessment says that they think that doctors and social workers will have the largest role, which suggests that others will have a role to play. And I would anticipate that, yes, in hospitals, in CHC cases as well, nurses will have a role to play. And there's no reason why they shouldn't.
Thanks, Neil. Michelle asks, my understanding for the CCGs being the responsible body is only where in speech marks as per section 6E of the National Health Service Act 2006. If you can comment on that, Neil.
Section 6E. Oh, let me think.
Yeah. I'm sorry, I can't help you with that at all.
Basically, CCGs will be responsible where the arrangements are mainly through, right, to give you the sort of legislation verbatim, where the arrangements are mainly through the provision of NHS continuing healthcare. So that's how the legislation is defined. And as I say, you know, we have in the national framework a definition of NHS continuing healthcare. So that's what we would use, primary health need.
Celia asks, is there a new definition of the deprivation of liberty or liberty protection safeguards?
No, Celia, we still use Cheshire West.
Thank you. Andy asks, at what level does a person need to be objecting to care and treatment before they're entitled to a COP appeal? Many object to some element of care, for example, personal care at times, or receive covert meds. Will those all now be COP cases?
Refusing personal care, having covert meds, that must trigger an AMCP, because obviously this is against their wishes. So you would expect an AMCP to be involved in those cases. In terms of COP appeals, we will continue, I would have thought, to use the current case law. So it's the RE-RD case, that's the key one, that determines when we should challenge an authorisation in court. So I don't anticipate that's going to change at all.
So the bar, Neil, is still fairly low. It's still just a basic objection. Yeah,
well, if I've got capacity and I wish to go to court, off to court we go. Mm. If I lack capacity, but I would wish to apply to court, off to court we go. And if I'm entirely happy where I am, but my representative thinks it's in my best interests for us to challenge this in court, off to court we go. And I don't think any of that's going to change.
Thank you. Andy asks, at what level does a person... Oh, so we've just done that. Sorry, Andy. Oh, 2 pops at that. So David asks, what factors will trigger a review, bearing in mind that after 2 one-year authorisations, the following is for 3 years?
Yeah, thanks, David, because I kind of skipped over that. It's in the slides, but as you say, under LPS, it's up to a year, and then up to 3 years, which is obviously quite different. But as compensation, if you like, for that, we can have a review programme during those authorised periods to ensure that people keep an eye on the necessity and proportionality of the arrangements and maybe the person's capacity if that might change. So in terms of what factors will trigger a review, the legislation itself is generously worded, to be honest, as long as it's considered to be, as long as it's a reasonable request, anyone with an interest in the care arrangements can trigger that review. So again, the bar will be very low there.
And Carolina asks, could you please explain the difference between restriction and deprivation, or maybe give an example? Thank you.
Oh God, Carolina. I see the Cheshire West case in a nutshell. We have spent the best part of 10 years trying to work out what the difference is. The Cheshire West case essentially says that if you're under continuous supervision and control and you're not free to pack up your bags and leave, and you lack capacity to consent to those arrangements, you're deprived. It doesn't matter how delighted you are to be there, gilded cage is still a cage. So Cheshire West is where to look. If you want a huge amount of depth and detail with lots of examples, if you just Google Law Society Deprivation of Liberty Guidance, you'll see from 2015, a number of us put together a lot of guidance about where the line is between restricting and depriving.
Thank you. Victoria asks, will a new authorisation be needed if the responsible body changes during the time of their current authorisation, for example, becomes ineligible for CHC funding, or can it be transferred between responsible bodies?
It's not very portable. And of course, if I am, let's say, in a care home where the local authority has authorised my deprivation, and then I become entitled to NHS continuing healthcare, the CCG then takes over the responsibility. And there is some scope for varying authorisations, but given it's a new responsible body, that might be tricky. So it's not very. The good thing about LPS is that it's focusing on the care arrangements rather than kind of detention in a more conventional sense. So it can cover things like supported living plus being taken to and from a day service. Do you know what I mean? If that's all part of the care arrangements, then the authorisation can cover conveyance and being at the day service. But it's not very portable, certainly when the place of detention changes, and it's not that portable when the responsible body changes.
I'm just going to ask one more question, Neil, because we're running out of time, but I have to say you've got a zillion more questions, which I'll let you have copies of, and also your slides will be available as well. But I'll just take one from Arjun, who says, I work in a hospice. Some of our patients will have CHC funding when admitted and some won't. Do we count as an independent hospital? Will we have a mix and match? Will we have to mix and match our responsible bodies?
Oh, okay. I think the short answer, Arjun, is yes. So those, in the same way as for care homes, those who are under continuing healthcare funding, it will be the CCG that's responsible. And for non-continuing healthcare funding cases, I would imagine that Most hospices are registered as independent hospitals. Not all, but most are. So in that case, it would be the local authority that is responsible for the deprivation of liberty. So yeah, it does very much depend on how they're funded, in the same way as in care homes.
Thank you, Neil. Can I just say a massive thank you from me and the rest of our team, and thank you to everybody who attended today. It's been extremely helpful and very impressive, Neil. Thank you as usual for your fantastic delivery on a very important subject. So thank you again for your time.
My pleasure.
Thank you, everybody. Bye-bye.